Good afternoon. This is the clerk of the court, and it is 1 p.m. in Washington, D.C. Presiding Judge Allen, the conference is configured for oral argument this afternoon, with recording and live video streaming now up and running. Counsel are prepared to argue, and all participants are ready to proceed.
You may call the court, Mr. Black.
United States Court of Appeals for Veterans Claims is now in session. The Honorable Michael P. Allen presiding. God bless the United States and this honorable court.
Good afternoon. This is Judge Allen, and I'm joined by my colleagues, Judge Meredith and Judge Laurer. We're convened via video conference to consider arguments in the matter of J. Ronnie Freund and Mary S. Mathewson versus Dennis McDonough, Secretary of Veterans Affairs, case number 21-4168. Will counsel, beginning with the petitioner's counsel, please enter your appearance?
Thank you, Your Honor. John Niles, and with me remotely is Kenny Dojaquez. We represent the petitioners.
Thank you, Mr. Niles.
Good afternoon, Your Honor. This is Alexander Yu, representing the Secretary. With me today is Drew Silo, Deputy Chief Counsel with the Secretary.
Thank you, Mr. Yu. And Mr. Niles, I understand that you want to reserve 5 minutes for rebuttal.
Yes, Your Honor.
All right, we've made that happen, and you can proceed when you're ready.
Thank you, Your Honor, and may it please the court. This case involves the thousands of timely perfected legacy appeals that VA erroneously and without notice has closed and withheld all action on ever since. There is no dispute that the withholding of all action on these appeals is unlawful. And there is no dispute that when Ms. Freund and Mrs. Mathewson filed their petition and their request for class action, VA erroneously had closed their appeals and was withholding all action on them. Now, the Secretary since has reactivated their appeals, which has prompted several questions in this case that I will, or at least intend to address today. But before I do want to note that the petitioners stand by all of their briefing in this case, which addresses why this court has jurisdiction, why it should grant the individual relief that the petitioners seek in addition to their appeals being reactivated, why this action meets the numerosity, commonality, typicality, adequacy, single injunctive, superiority, in short, all of the requirements for class certification, and also why this court should grant class-wide relief. Today, I intend to address 4 issues, which I now will preview, and then at this court's pleasure, we'll start delving into in more detail. The first is why, no matter which basis this court uses or invokes to open its jurisdictional doors, 38 U.S.C. Section 7261A2 standard of mere unlawfulness is what governs the question of entitlement to remedy. The second issue is why the individual petitioner's claims are not moot. The third is, in the alternative, why this action satisfies the requirements for the inherently transitory exception to mootness that this court has adopted for putative class actions. And the fourth issue is a question that we understand the court to be asking in the alternative to class certification, which is that if the court were to reach this issue, should it adopt an inherently transitory exception to mootness generally for all cases? And so petitioners have 2 responses to that, which I'll preview here. The first is that at the threshold, petitioners do ask the court not reach that question in this case, but instead certify the class. But if it were to, then yes, this court should adopt a modified version of the inherently transitory exception to mootness generally for all cases, which I will address further. And so the first of these issues is why 7261A2's mere unlawfulness standard governs entitlement to remedy. Petitioner's position is that they do not need to carry relief out of this court using the same door that the court has opened to let them in.
So, Mr. Niles, can I ask you just to see if we can short circuit a little bit on this first? Is your position then that the U.S. Supreme Court's articulation of the 3 requirements necessary to justify the issuance of an extraordinary writ under the All Writs Act doesn't apply to this court because of 7261?
I have the petitioner's argument or a position on that is a little bit more nuanced, which is that certainly if a petitioner comes to this case asking only for issuance of a writ of mandamus, then that standard would apply. And historically, that's exactly what this court has seen. Petitioners come in, they ask for issuance of writ of mandamus, and that is it. And so it's petitioner's position that what they're doing there is overlooking that that's right. Congress here has put in 7261A2, which says that this court shall compel action unlawfully withheld. And so when a petitioner is asserting that basis for remedy, then it is that less restrictive standard of mere unlawfulness that applies.
So then so leaving aside inartful drafting by other lawyers, your argument though would be in any case in which to use your metaphor, the jurisdictional door is opened via the All Writs Act, meaning there is not a final board decision to appeal. Once the jurisdictional door is open and somebody crosses the threshold, we no longer should follow Cheney because Cheney doesn't apply. 7261's standard would apply for whether or not to issue relief. I just want to make sure I get that right, that there's nothing special you're saying that exists only in this case as opposed to another, other than perhaps that you asked for this expressly.
That's correct, Your Honor. Once a petitioner is in, the petitioner is in, and this court's non-jurisdictional statutes govern, 7261 being one of those, and saying that for any action brought under Chapter 72, which no matter whether this court were to open the jurisdictional door here under 7252C or in aid of 7252A would be under Chapter 72. And so the standard of mere unlawfulness applies. And that does encapsulate the petitioner's position on that first issue. And so I will now proceed to the second issue, which is why the individual cases are not moot. And the short answer here is that the petitioners asked for more than merely the act of reactivating their appeals. The legal standard that the Secretary has to meet to demonstrate mootness is very stringent. The Secretary has to show that it is not possible for this court to grant any effectual relief whatsoever. And here the petitioners specifically requested that the court hold the Secretary's withholding of action on their erroneously closed appeals to be unlawful. And that matters because, yes, the Secretary now has reactivated these appeals, but the claims are still ongoing, and they are in a posture where both of the petitioners are having to provide additional evidence to support the entitlements they seek. Ms. Freund is seeking service connection for psychiatric disorder about events that occurred in 1970. And Mrs. Mathewson, who is now proceeding as a substitute claimant because during this period where VA had erroneously closed the appeal and was withholding all action on it, her husband, Mr. Mathewson, who was the original claimant, passed away.
Mr. Niles, are you familiar with a U.S. Supreme Court case called Lyons versus the City of Los Angeles?
Only vaguely, Your Honor.
Well, that's okay. You probably didn't teach constitutional law for 2 decades, so that's okay. So in that case, the claimant filed a civil rights action. He had been put in a chokehold by the LAPD, and he sought damages, and that case went forward. That was clearly okay. But he also sought a declaration that the use of that type of force was unlawful. And the US Supreme Court said, not that that was moot, because obviously damages claims aren't moot, right? But as to the declaration, the Supreme Court actually said it's not ripe, meaning he couldn't show that there was any likelihood that he would be placed into a chokehold again. And so the fact that he asked for a declaration in the abstract that this type of conduct was unlawful wasn't good enough to get the hook for the court to say anything about that. So in your case, it's sort of similar, it strikes me, because there's no indication that VA is going to erroneously close your appeal again. And to the extent that there is prejudice in your appeal because of what VA did, wouldn't you then simply raise that prejudice to the agency? And if the agency acted inappropriately in your view and ruled against your client, you could appeal, and we would then be able to address that issue at the time of the appeal.
I would have if your honor would indulge me, I have a follow-up question about Lyons, which is whether the choker policy came into effect after the appeal was filed versus was existing at the time, and that's when I guess it sounds like it was existing at the time.
Well, the oddity of Lyons for those who when it came out was, one would think that a pretty good indicator that you might be subject to being put in a chokehold is if you've been put in a chokehold. But the Supreme Court said that's not good enough. That's what damages are for. That's in the past. Unless you can show that you're likely to be put in a chokehold in the future, you don't have any ability now to claim as an injunctive relief matter that policy is unlawful. You might be able to do that in the damages matter, but not in the injunctive matter. And so my point here is, your appeals were closed, they were reopened. So to the extent that that was the relief you were seeking, you got it. The only other concrete relief I think that you're pointing to is your request that a declaration that the process by which the appeal was closed was unlawful. But I'm not sure how we reached that here, given that your claims have been turned back on. And to the extent you were harmed by the policy and want to say that was an unlawful harm, you can raise that to the agency. That's what I'm struggling with in this context.
And the trouble that I'm having extending the analogy from Lyons, what I understand of it is there's a difference between damages and injunctive relief on the one hand versus for this court to grant for this court to have granted relief from unlawful withholding, it would have had to have been unlawful. And so part and parcel of the petition, right, of the core of this petition, saying that the secretary has been erroneously closed and withholding all action on this appeal, and for the court to do anything about it, it already would have had to have been unlawful when the petition was filed. And so right when the petition was filed, and so I'm struggling with how a petition ripe when brought would become unripe during the course of it based on the secretary taking unilateral action that then sort of deprives this court of the opportunity to provide the judicial imprimatur that would have helped not only currently, but also going forward. And so I am answering on the spot here a little bit with Lyons. I do apologize for that, but I want to try to be at least helpful for the court.
No, that's okay. What I'm trying to wrestle with is this, right? Take the potential class action out of it, okay? The petitioner comes to the court and says, I've got this problem. My appeal's off. It should be on. VA turns the appeal on, okay? Now, at that point, what you're saying is, yes, but you can still now, in the extraordinary writ context, determine whether or not it was turned off unlawfully. What I'm trying to struggle with is, well, but what's the reason we can do that? Because if it was turned off unlawfully and you were harmed, you can assert that to the agency as part of the ongoing administrative process, and then we get it in an appeal. To the extent you're saying, oh no, because we could still be harmed in the future by this, that's the Lyons point, right? Because you can't show that it's likely they're going to turn your appeal off again. And so that's the struggle I'm having with the idea that your individual claims aren't moot. Because in reality, once the appeals are turned back on, I'm not sure there's any hook for the court to be able to say whether something was unlawful or not at all, because they're not off anymore.
I will attempt a very short response to this, and then at this court's pleasure, would like to move on to other points. The short response is the difference between the petitioners coming to this court seeking relief from an unlawful withholding. And during the pendency of that, the withholding stops because of unilateral action that the secretary has taken. without the accompanying concession or acknowledgement that the withholding had been unlawful and the different position that leaves them in. But I do think, if this court's pleasure, I will move on and address the second point, which is why, let's assume that the individual claims are moot or otherwise would be. The inherently transitory exception to mootness for putative class actions.
Can I stop you there before we move on to inherently transitory? There were basically two questions that you've asked the court to answer. You discussed one of them with Judge Allen, is whether there was an unlawful withholding of action. But the other one is you've asked us to decide whether or not VA violated fair process or regulation in not providing notice upon closing the petitioner's appeals. And so I want to ask you if you could explain how we would have standing as to that question, because the petitioners in their petition acknowledged that they were aware that their appeals had been closed. So what remedy could we provide even if we were to find that there had been a fair process violation?
So with the petitioners, the individual cases, at this point, if this court were otherwise to, I'm trying to distinguish between mootness versus standing. The petitioners were harmed by this lack of notice for quite some time before they came to this court. And the lack of notice, which the petitioners assert violated 1932, the regulation 1932, and also fair process, the harm that they suffered from that, including the loss of evidence. What
court order could we issue today that would redress that harm, that alleged harm of the failure to notify? And you've mentioned reinstatement of the appeal. If there's no real other concrete, as you mentioned, no other concrete relief you're seeking.
And I was being so slow and hesitant for responding because I was trying to work around this ripeness question, but I'm just going to go right through it. And if it's a problem, it's a problem. These are still ongoing claims where the petitioners, are in a position below where they have to add more evidence to establish the entitlement. And the unlawfulness of this withholding and the loss of evidence that occurred during it, if they are correct, that if that is the fault of the government, such that it triggers the heightened duty to assist and the heightened duty to take into account the benefit of the doubt doctrine, then at that point, this court, providing the relief requested in the individual cases, would help them going forward. And
so you're talking again about the unlawful withholding, not the fair process violation. But let me get to a couple points. When did your firm—
Judge Meredith, can I interrupt 1 second? I just want to say something to both counsel. I didn't clear it with my panel mates, but I think they're going to agree. There are a lot of issues in this case, so don't be so focused on the time, Mr. Niles or Mr. Yu. We're going to make sure that all our questions get answered and you get to touch on the points you need to touch on. I just didn't want you to be getting nervous, okay? Judge Meredith.
Thank you. You mentioned the delay that occurred here. As you know, your firm represented both of the petitioners before the agency. At what point did your law firm become aware that these appeals had been closed inappropriately?
It was late the calendar year before we brought the petition, so late in 2020.
And prior to filing the petition, assuming we're proceeding under the AWA framework, did the petitioners take any action to try to get VA to reinstate their appeals?
No, Your Honor, they did not, and that goes to remedy under the All Writs Act as opposed to jurisdiction. And of course, their position is that once they are in, they are in. And Congress does not intend for this court to stand by when the Secretary is unlawfully withholding any action, including all action on a timely perfected legacy appeal. Your Honor also was asking, or I understood Your Honor to be distinguishing completely between, on the one hand, the unlawful withholding, on the other hand, this notice issue, but they are interrelated. And we see that in the Secretary's filings with the references to this M21.5 provision, where if the Secretary or through the Veterans Benefits Administration becomes aware of an erroneous closure, then they will reactivate the appeal. The deprivation of any notice to the petitioners left them in a worse position to be able to identify that their appeal had been erroneously closed. All they can see is they've perfected their appeal. It's up before the board. They know the board has long delays, and they don't know that the appeals have been closed. Meanwhile, they are losing access to that evidence that they still need to be able to establish the underlying entitlements.
So you're back to the heightened duties, triggering the heightened duties. Is that
Yes,
the
sir.
concrete relief? So as to that, again, assuming that we're proceeding under the AWA framework, how would issuing a declaration along those lines be an aid of our prospective jurisdiction of just saying you unlawfully withheld action and potentially that triggers these heightened duties? How does just triggering those duties lead to a board decision? And why wouldn't the petitioners be able to remedy that through the appeals process?
Once this court gets to that question, then it already, the Secretary's reactivation already would have helped the prospective jurisdiction and alleviated that particular issue. But at that point, the petitioners submit that they are in. And so they are asking relief not only for them, but for the thousands of similarly situated appellants who timely perfected these appeals and from whom the Secretary has been unlawfully withholding all action. And if you're,
Please finish. That's fine.
oh, I'm sorry, I was about to move on to the next issue, but I didn't want to go there.
Okay. As to the broader class issues, you've asked us to answer those two specific questions as the purported common questions that would hold the class together of, was there an unlawful withholding and were there these fair process violations? But I think you just acknowledged a while back that in order to reactivate an appeal, simply identifying a timely filed substantive appeal is enough. The VA then has an obligation to reinstate the appeal. So if the ultimate objective is to reopen, reactivate the appeals of the entire class, why would we need to answer either of the common questions that you posed? Isn't the only relevant question whether they had timely Form 9s filed?
And I'm sorry, Your Honor, I haven't conceived of it in quite that way. Would you mind rephrasing? Just I want to make sure I'm answering your question.
You've posed two common questions that you believe we should answer on a class-wide basis. But ultimately, what you're seeking is to have the appeals reinstated for the entire class. If the only thing we need to know is that there was a timely appeal, why would we have to delve into, were your fair process rights violated? Was there an unlawful withholding? All we need to know, and all VA needs to know, is there was a substantive appeal that was timely filed. So how do those questions that don't speak to the Form 9, how are they relevant to the ultimate relief that you're seeking on behalf of the class?
Your Honor, I believe that I understand your question. I'll respond as follows. This is not an issues class action or a class action that is restrictive to a particular issue. It is a class action seeking relief from the Secretary's unlawful withholding, including the notice aspect of that withholding, so that these petitioners do get their, or rather the putative class members do get their appeals back on track. And so it is not so limited where if this court were to chop up the separate questions that then the petitioners believe that denying class relief would be appropriate. Rather, the petitioners asked that this court look at the class action device as being a procedural remedy that can provide systemic relief to a systemic procedural wrong. What we are seeing here as far as the procedural wrong, and I think that the Secretary's supplemental response they filed in January makes crystal clear that, number one, every single one of these erroneous closures are happening because VA is relying on this automated vehicles system with no human oversight. And number two, there is nothing that the secretary is doing systemically to address this, what is the systemic problem of the VA's own creation, right? It's only if a rating officer stumbles across an individual case on an individualized basis that they will reactivate that one. And so we see these, 323 average monthly reactivations VA-wide through September 2020 and something like 40 monthly since. That is a minority, and that's good, that's some progress, but it is a minority of the problem here, where there are, we believe, thousands of erroneously closed appeals going back years that are still hanging out there while these claimants are dying. And meanwhile, Your Honor is absolutely correct that they have timely perfected their appeals. The board's duty to consider them or for VBA to issue an appealable decision as to untimeliness is absolute. And so they are seeking class-wide relief from these and the related notice errors where, and I say related notice errors because again, if VBA is relying on it, just waiting for an individualized case-by-case determination, a really good way to find out about that would be to let the veteran or the claimant know that these appeals have been closed.
So as to that point, if I could jump in there, your definition, the class definition that you've put forward actually says that to be a class member, they have to have had a timely perfected legacy appeal. And so I think you just acknowledged that requires an individual determination by VA to see what was filed, when it was filed, or whether the requirement can be waived. So how would the court or VA determine who falls within your class definition without doing that individualized assessment?
Yes, Your Honor, and we are leaving a lot of people behind, and we're doing that in the name
Niles,
of—
hold on 1 second. Dawn, you can put 10 minutes on the clock. Thanks. Go ahead, Mr. Niles.
Thank you, Your Honor. And so the petitioners are leaving a lot of people out of the class definition, and they're doing that because they want to make this as manageable as possible. So not only do they have to be legacy appeals, not only do they have to be original appeals, the Form 9, they have to be in Bakels, and the Form 9 has to be in BBMS. And so this is something we realized that these databases go back years. Essentially, we're asking for the same type of determinations that VA already leaves blindly to an automated system with no human oversight to start, right? It's a cross-referencing of—
I'm not sure that's answering the question I asked. So how would VA know if there had been a timely filed substantive appeal for each purported class member without going through each file and making an individual assessment as to what they filed and when?
So in VBMS, there is a date of document, and there is an associated type of document and metadata that describes this is a Form 9, and what we understand is this is when it came in. And certainly we want to verify this, and we think that it would be, and we've allowed for this in the request for class action. So a meet and confer process to make sure we're doing this the most efficient way. But ultimately what we are hoping is that we are able to rely on VA's existing database to do searches, database-wide searches, and do this electronically and get a large number of erroneously closed appeals identified and get them moving again.
So would your class only encompass cases where VA has already made this individual assessment and put it into the system that says there's a timely Form 9?
Oh, I see. No, Your Honor. By timely Form 9, we were using an objective criterion. They were filed within what is generally the 60-day period, which then can be determined through essentially database queries and arithmetic, as far as subtracting the one date, the Form 9 date, from the date of the statement of the case.
It wouldn't account for things like equitable tolling, constructive receipt, misfilings.
That's right, and those folks would be left out, and they would have to come in on an individual basis. But we're hoping to scoop up a lot, as many people as we can, will reasonably do to get their appeals back on track. And we believe again that we would be helping thousands of veterans whose appeals have been warehoused by this technological practice.
So I just want to circle back to one thing before I we've now talked about what's required to reactivate an appeal. A timely 9 may involve an individual assessment, but the common questions that you've put forward as to why we should go to class don't have anything to do with whether the individual filed a timely substantive appeal. It has to do with things that happened after the closure. So was notice provided, was action delayed or withheld? Why are those common questions to should we reinstate these erroneously closed appeals?
The reason, Your Honors, the petitioners have baked in to the class definition that they have timely filed these appeals, right? And so it's not something that it's defining whether they're in or out of the class, as opposed to whether the class as defined should be certified. And so they're asking the class as defined to be certified, knowing that it's leaving out a lot of veterans and their survivors.
Didn't still really hear an answer to that, but Judge Allen, it looked like you wanted to jump in.
Nope, just shifting.
And I'm struggling because I really do want to address your Honor's concerns. Commonality is a fairly broad inquiry in that all we need is one common issue of law or fact here, which can include the unlawful withholding. And so I'm having, to be parsing so finely, I fear would reframe the analysis to something that is more restrictive than the law and class actions requires. And so I would ask that the court look at the commonality standard that this court has adopted in its prior class action cases and pulling out from, say, the Walmart case and be applying that standard.
And so here's the language. Here's language that we used in our Monk plurality opinion as to the common questions. Certifying court must be convinced that the claims of every class member depend upon a common contention that is capable of class-wide resolution, and the truth or falsity of which will resolve an issue that is central to the validity of each one of the claims. But my point is, you put forth two questions that don't speak to whether an appeal should be reinstated. So how can those be the common questions that depend, that all of the class members' claims depend on?
In the petitioner's understanding, they have petitioned for relief from an unlawful withholding of all action in their appeals that was caused by the erroneous closure of their timely perfected legacy appeals. And that every single class member also would be seeking, if not on a class basis, an individualized basis, would be the same questions over and over again, thousands of times, seeking relief from the unlawful withholding of action on their timely perfected legacy appeals because the secretary erroneously closed them using what we now know is this single common Bakel's automated function with no notice and no oversight, which has left them in this lurch for so long and has been unlawful from day one because these appeals have been timely perfected. And so I also will mention that in the petitioner's understanding, the Monk four-judge decision is essentially a concurrence in terms of weight of authority. And so we would urge this court to cite to the Godsey, the Wolf, Kate Baudet, where there is a majority opinion to be cited there. As far as the inherently transitory exception to mootness that this court has adopted for putative class actions, it has three requirements. The first is that the matter not have been moot when the petitioners filed the request for class action. It's not in dispute here that requirement is satisfied. The complaint of behavior has to be inherently transitory in nature such that the secretary essentially could swoop in and provide it before this court reaches determination on the class motion. And we know that reactivating an appeal is a matter of a few mouse clicks and a few keystrokes. We're talking seconds, or if the databases are slow, maybe minutes, but still plainly before this court could reach the resolution of a class motion. And then third, that it is likely that other putative class members suffer the same wrong on an ongoing basis. Exhibit C14 shows our math on that. We believe that there are thousands in that it's not just likely, but certain that other veterans and their survivors are still suffering the same ongoing harm. As far as the Final question, which the petitioners understand this court to be asking in the alternative to class certification at all. Should it adopt a generally applicable exception to mootness on the basis of inherently transitory? And the petitioners.
Mr. Niles, on
Yes, sir.
that point, I just want to make sure I understand, because I did not understand our order to be asking about inherently transitory outside of the class context more generally. I'm not aware of any situation where the individual claim can be moot and the court could proceed to answer a question if there weren't also a class issue involved. Do you have situations that fall into that bucket, which seems to be what you're talking about now?
100% agree that in Article 3 courts, there's nothing there, and on current law before this court, there's nothing there. And so this would be an extension. If this is not the question that the court intended to ask, we were latching onto this word generally and understanding it to mean of general applicability for all cases, class actions or not. And so if that's not the court's question, then I don't think it would be fruitful for us to discuss it. And I'd be happy not to. I mean, we're all taking up time.
Well, I don't think, I'm not sure, I don't want to speak for the panel. I think what we were thinking, or what I was thinking, was we had used that once in Godsey. We discussed briefly the inherently transitory concept, and we referred to it in a case called Haddock briefly. But we really hadn't sat down in an opinion and really spent a lot of time focusing on that type of situation. So I had understood that to be the language more generally to be focused on that. I don't think it would be particularly fruitful, in my view, for you to spend your remaining seconds here on that if we take the class out of it. So of course I defer to Judge Meredith and Judge Laurer on that. So
hearing no urgent desire to hear about this question, I will then say that by analogy to Godsey, or by comparison to Godsey, there this court adopted and applied the inherently transitory exception to mootness when the complainant behavior was unreasonable delay in pre-certification review, which is more time intensive than the simple matter of mouse clicks and keystrokes, small amount that would take to reactivate an appeal. I see that my time is expired, Your Honors, and I look forward to speaking more in rebuttal.
let me just make sure, Judge Meredith, do you have anything else before Mr. Niles sits down?
Not at this time. Thank you.
Judge Laurer?
If I may, thank you, Judge Allen. Just follow up on Judge Meredith's line of questioning earlier for Mr. Niles. What should veterans do when they believe that their board appeal was improperly closed, in your opinion?
Your Honor, assuming that they can find out, which again, they have for the longest time, no reason to suspect that anything at all is wrong other than just board delay. What they should do is contact the Office of Administrative Review, say, hey, this is when I provided my substantive appeal. If possible, provide a copy of it so that the Office of Administrative Review can say, yep, this is in. Provide the date of the statement of the case. And best practice would be to subtract the dates from each other to say that this is within 60 days, so go ahead and get it moving again. But again, that is on an individual basis. And we're talking about a population of veterans who are seeking, and their survivors who are seeking entitlements because of ultimately disability, and also the vast majority of whom are unrepresented. And even among representatives, I don't know how many representatives in our industry would be able to go in and really determine that there's a problem here at all.
Thank you.
Thank you, Mr. Niles. Mr. Yu, and you should recognize that you'll have as much time as you need to respond to our questions and answer, because we gave Mr. Niles some extra time.
Thank you, Your Honor. May it please the court. In this case, the court should dismiss the petition as moot and deny the RCA. However, even if the court were to find that the inherently transitory exception to mootness applies in this case, the court should reject petitioner's arguments for 3 reasons. First, VA's practices of automatically closing an appeal is consistent with governing statutes and regulations, which petitioners do not challenge in this case. Second, the governing statutes and regulations here do not require VA to provide notice when VA closes an appeal in vehicles. And third, VA has adequate processes and procedures for identifying a VA 409 and reactivating prematurely closed appeals to include addressing situations in which a VA Form 9 is missed due to human error. Before the court reaches the merits issues here, the court should first find that the individual claims of petitioners are moot and dismiss the petition as such. As Judge
I hate to jump in at the beginning. I have a factual question that I wasn't in the full extent, very extensive briefing, obviously, in this matter. Can you tell me why the two petitioners' appeals were closed?
In response, Your Honor, it's not certain. VA is not certain why they were deactivated prematurely. As best as we can tell, it was due to human error. That despite the procedures in place, human error resulted in the VA Form 9 not being properly identified and processed and entered into VBMS and vehicles.
So, I don't mean to press you on this, right? So you're the best. So first, we don't know why they were closed, and I appreciate the answer that being forthright. But the best guess, and I'm not being pejorative, the best hypothetical is that there was a human error with respect to entering. Now, the thing that I'm curious about is, but the appeals were closed via an automated process, right? In other words, the sweeping function in vehicles. And so the human error you're suggesting is the Form 9 came in on day 60 minus 10, okay, day 50. A human somewhere didn't enter that into vehicles appropriately. And so when vehicles automatically ran the report on day 60 in my hypothetical, it showed no Form 9 and therefore it was closed. That's sort of the best hypothetical guess you have for this. Is that, am I encapsulating that about right?
Yes, Your Honor. The only caveat I would point there, though, is that there are other potential reasons why human error would result in the VA Form 9 missed, not simply that it wasn't entered into VBMS or vehicles correctly. For example, if it was not properly identified as part of the mail intake procedures. But you are correct, Your Honor, that generally speaking, when I say that human error resulted in these appeals being prematurely closed and not properly reactivated, is because at some point in the process where a person would have identified that VA Form 9 and enter that information in the vehicles, they failed to do so, despite VA's procedures.
Right, and so there are, any number of reasons why that could have happened. Form 9 could have slipped behind a desk and then it's picked up the next day, right? But that the thing that then actually closes the appeal itself isn't human error, right? It is the operation of the vehicles program showing that there isn't a Form 9, right?
Yes, you're correct, Your Honor, that VA does use an automated program as part of vehicles to close out appeals on the first day of the month following 65 days after the issuance of the SOC. And if the VA Form 9 is not identified in vehicles, then it will be closed automatically.
Yes, and I just want to assure you, these questions are not meant to be traps. They are literally meant to be making sure that I understand that there are lots of things that can happen before there's a computer program that operates, but the operation of the computer program is the same, and it's not that's human error. It's not that, oh, I got to run the computer program and I should have hit 1, but I hit 2. It's not that. It's something else happened ahead of time, right?
You are correct, Your Honor. The most immediate cause for the closure of an appeal is the automated program that is part of vehicles.
So, and then to follow up on that, in the briefing order that we issued, to which you responded in January, I think, one of the questions we asked was a follow-up to something in the secretary's response, I think, to the petition. It could have been to the class, but I think it was the petition that used language about VA taking, proactive steps to fix things. My words, not yours, but the word proactive was in the brief. And we asked you to just be a little bit more specific about what it is that VA was doing. And I just want to make sure, again, these aren't trap questions. I just want to make sure I understand the response. Because what the response seemed to me was, I couldn't figure out if VA now was doing something in response to this petition being filed where this issue has come up, because it seemed that the response said, well, after the OIG's report in 2017, I think, we adopted certain procedures in the manual, basically, about how we do things when they come in the door, right?
Correct.
And then the second part of it was, and we've got this rule, colloquially used here, rule that says when we find out that there's actually a timely Form 9, we turn the appeal back on, right?
Correct, Your Honor.
I couldn't figure out whether there was something else that you, the secretary, meant by this proactive activity. And the reason that I want to be clear about that is that both Ms. Freund and Ms. Matthewson's issues occurred after the adoption of that procedure in response to the OIG report, right? Both of them had their Form 9s missed, if you will, after, and they didn't get turned back on until the petition was filed. And so I'm just trying to, right, and so what I'm just trying to figure out is whether there is something now that's going on at the agency to try to figure out whether there is a way, regardless of what we do, right? Because the way my question now is sort of, VA knows that there are these pool of people that likely exist, right? That simply might be the result of the agency leveraging technology to use the vehicles program. We know some things are going to be missed. It seemed from your response to the petition that, okay, we're proactively dealing with that problem. But then when we were told what that proactive response was, I couldn't figure out what it was other than things that were in place before and missed Ms. Freund and Ms. Matthewson. Do you see what I'm asking?
Yes, Your Honor. If it's unclear from the supplemental response, we apologize, but VA has not undertaken or developed new procedures since the filing of this petition. We tried to highlight in the supplemental response that VA has multiple layers of procedures and processes for identifying a VA Form 9 and where necessary to reactivate the prematurely closed appeal. VA's procedures do recognize that there will be mistakes made, that some VA Form 9s will be missed, but VA's procedures are seeking to identify these VA Form 9s that were previously missed and reactivate the prematurely closed appeals. Your Honor, you're muted.
Sorry about that. I just want to make sure I get this though. So the point about actively identifying the Form 9s, that's when they're coming in the door, right? Things to make sure that VA reduces the human error component up front, right?
No, Your Honor, we would disagree with that characterization. Well, first, I would say that when we use the term proactively in the initial response, our intention was to explain that we are not just reactivating prematurely closed appeals in response to a writ petition, as occurred here. And it's not simply in response to when a veteran may send a request the RO to provide a status update. As part of VA's normal operating procedures, it does identify VA Form 9s that were previously filed, and if there is a prematurely closed appeal associated with that, to reactivate that appeal.
That's the part. I think that's the part that I didn't get from your supplemental briefing. In other words, because let me tell you the universe of people I'm concerned with. Okay, and I don't mean this to sound negative. I'm not concerned with the people like Ms. Freund and Ms. Matthewson, and by that I mean they found out their appeals were closed, and so you automatically reactivate them, you being VA, right? And I'm not so much concerned about the people who are sending in the Form 9s, because you've got procedures in place to try to make sure there isn't human error. But for people like Ms. Freund and Ms. Matthewson, before they found out the appeals were closed, they're in this middle group. And it seemed to me that your last answer said VA is doing something and has been, independent of this petition, to see if those people exist.
Yes, Your Honor. And
That's what I don't understand, because I did not get that from your supplemental briefing. So what are you doing?
yes, Your Honor, to specify, so not only is VA trying to identify these VA Form 9s at the front end, in the middle portion that your Judge Allen is referring to, VA does have various procedures to identify these missed VA Form 9s. As part of these procedures, VA claims processors do review the claims file at multiple stages in the appeals process for the purposes of ensuring the integrity of the claims file. So, for example, when a claim is being developed, when an initial decision is being made, and when a decision is authorized by a supervisor, various VA personnel will review the claims file to ensure that all the necessary information is being considered. And during those processes, if a timely filed VA Form 9 is identified, which has not been processed, then the appeal will be reactivated. Additionally,
But let's just take a very simple case. And I'm just trying to wrap my head around what's going on, okay? It is a one-issue case, okay? There's a rating decision, notice of disagreement, SOC, a timely Form 9 is submitted. Just through a human error, it's not entered into vehicles in time, so the vehicle's automatic run at day 60 plus 5, right, says, nope, it's not there. And so the appeal is closed. Nobody is ever going to look at that appeal again, right? Because there is no other thing that's going to be done unless you can tell me that there is some spot checking or something that goes on for an appeal that is closed, because all of what you're saying now makes perfect sense to me. Oh, this appeal is closed. They've got another claim for PTSD. A human's going to look at that file, and one of the things they're going to look for is, hey, whatever happened to that other appeal? Oh my God, there's a Form 9. That makes perfect sense. But that's catching the mistake by sort of accident, right? I just want to be clear. Is there anything that VA is doing or planning to do to try to figure out those people that were like Ms. Freund and Ms. Mathewson before they happened to find out their appeal were closed? Or is it all this sort of luck of the draw if you've got another claim and you get a good person in the St. Pete regional office that looks at the claims file?
Yes, Your Honor, in addition to the procedures that are highlighted previously, VA does have procedures for quality control review rate reviews, in which a reviewer will sample various cases for the purposes of identifying any errors and making sure those errors are corrected. In fiscal year 2021, VA conducted 30,000 such quality control reviews, in which the reviewer will evaluate or review the entire claims file. And if there are any errors present in the claims file, for example, if missed VA Form 9, that quality control review will ensure that the error is corrected.
Could I jump in there, Judge Allen?
Yes.
So I'm not sure if I've heard a clear answer to this question yet. Is VA looking through old files where there's otherwise no action necessary on the claim, going and looking at those old closed files to see if an appeal was accidentally closed?
No, Your Honor, VA does not currently have procedures for the sole purpose of identifying if in a claims file a missed VA Form 9 is present.
So let me ask you, in that 2018 Inspector General report that Judge Allen referenced, in response to the IG's concerns, VBA wrote this sentence: beyond the changes that VBA has already made to its end product procedures, VBA is in the process of updating the pre-site visit protocol to include a review of closed appeals records. What does that language mean?
Your Honor, unfortunately, I don't know what that language is specifically referring to. I do know that since the OIG report was issued, VA did revise its procedures to include updating the requirements for how an appeal to and including a VA Form 9 is tracked in VBMS using the end products and claim labels.
But there's been no, to your knowledge, no efforts by VA to go back and look at old closed files and see if there are appeals that were erroneously terminated.
To my understanding, there have been efforts, but that this is
Such
not.
as what? Can you
Uh,
provide us any information on that?
Unfortunately, I cannot provide you with more information on. My understanding is that there have been attempts in the past to review sample cases, old sample cases, for the purposes of identifying any errors, but it is not an ongoing effort.
Why would there not be documentation as to what efforts had gone on in the past?
I only know this in a very brief manner. I unfortunately cannot provide you, but I can provide you with a supplemental response if your honors are interested in additional details regarding VA's efforts in the past to identify or to review these older case files.
Well, I was just going to say, I think the panel will consider that, and so nobody has to submit anything until we tell you, Mr. Yu.
Yes, Your Honor.
So before we change topics, you argued that the petitioners have not shown numerosity, and their response was essentially, VA has all of the information. We don't. We've asked for it in a FOIA request and they haven't responded. So in light of the current petition, has VA done any research, searches in vehicles or VVMS, to try to determine what the potential pool is of people who might have had their cases erroneously closed?
Your Honor, directly to answer your question, no, VA has not attempted to identify these persons who are missed. And the reason why is because anytime VA identifies a timely filed VA Form 9 for which there is a closed appeal, VA's policy is to reactivate that appeal. So
Can I just stop you for 1 second on that point?
Yes.
The secretary repeats that over and over and over again in their brief, and I laud the secretary and VA for doing that. It seems like a very low cost, easy thing. Flipping a switch. As soon as you find out, you flip the switch, right? That's great. Without speaking for Judge Meredith, my question is, but that answer saying when we find out, we turn the appeal on, doesn't say anything about the universe of people who have had their appeals turned off. I mean, I think the secretary would concede there is at least one of them. It's not like it's not like it's a unicorn, right? It's made up. They exist. And I think what we're getting from my perspective, my questions on this point are, this case presents a slew of very complex legal issues. They're jurisdictional, they're all of this, right? And maybe the answer is that the court says, we can't do anything. I think our questions are, though, at least from my perspective, there is this problem. And what we have just been trying to get at in the first 20 minutes of the argument, and I think I understand the answer now, is, are you doing anything to actually look for those people? And the answer seems to be, we put in procedures after the OIG to try to make the input better with the marking the end products, right? And as soon as we find out that there's a closed appeal, we flip it on. And there are various times that somebody might touch a claims file later on, and if we see an erroneously closed appeal, we'll turn it on. But as to the people who are erroneously closed, and none of that tends to happen, the answer appears to be, and this may have no legal significance, the answer appears to be the secretary's position is, we are going to do nothing with respect to those people other than turn them on if they happen to come across our desk. Is that right?
Your Honor, to respond to your question, the only way for VA to identify these missed cases in which the procedures are not capturing the VA Form 9 and for the purposes of reactivation would be if VA were to review every claims file individually. Now, the Secretary's procedures our recognition that the processing of appeals is paramount, and we do believe that we are catching the vast majority of these missed VA Form 9s. As previously stated in our initial response to the RCA and the petition, VA is actively reactivating these appeals on an ongoing basis. And so the various procedures we do have in place are not just for the intake procedures for the VA Form 9s, but also, as you've pointed out, and then as I've noted previously, that there are various stages. If a VA Form 9 is identified, then then VA will reactivate that appeal.
And so the only, just so I'm clear, is it the secretary's position that, because I don't know the answer to this at all, what it seems like you just said, which is something that wasn't in any of the briefing, is we couldn't do this without reviewing every single file individually. Is that now, so there's no, there is a technological way to close them, but there is no technological way to review? Because if that's the answer, that's an important piece of information. I would have liked to have had that piece of information, but is that the point?
Yes, Your Honor, because VA doesn't track the VA Form 9s, which it doesn't know about, which is effectively the question that Judge Meredith is trying to get at. I believe that for those VA Form 9s which VA is unaware of, the policy would not implement it. The policy would not be implemented, and that VA form or that appeal would not be reactivated.
Except VA does track, I would assume, appeals that have been closed because there is no Form 9 on file as of the 65th day, right?
That is correct.
So the universe of people is the universe of people that vehicles could tell you, if the secretary wanted, the secretary could look and say, in the last 90 days, X number of people have had their appeals closed, right? And the secretary could, if the secretary wanted, implement some program to either look at those files or spot check those files, right?
Yes, Your Honor. We would just note that the vast majority of appeals which are closed properly because the VA Form 9 was not received. And
how do you know that? How do you know that? Right. I mean, it seems that the secretary knows that there are erroneous closings, right? We know that because we've got 2 here. And we know that your own Office of Inspector General made a big deal of this. And it seems that the secretary's position, and you might be able to absolutely insulate this from judicial review, but the agency does have the big Abraham Lincoln quote on the side of the building, right? And so I would encourage you, after the argument, whether we issue a supplemental order asking you to provide information or not, to at least and when I say you, I mean the secretary, Mr. Yu, to consider the fact that there is a group of people who apparently there's a problem and it's very difficult to capture them. So that's all we were trying to get at, or I was trying to get at.
Yes, Your Honor, and the secretary acknowledges that, but we would ask that the court not still deny the RCA in this case under Rule 23, because even if the court were to find that numerosity is satisfied here, and that there are in fact a group of people, and that petitioners have sufficiently demonstrated to the court that there are a group of people who would fall under the class, that the court should still deny the RCA because petitioners have not demonstrated the commonality requirement. As Judge Meredith—
Before we move on to commonality, I'd like to actually follow up on some of what Judge Allen just said. So in response to the RCA, VA took the position in part that VA is already providing the relief sought by petitioners. But petitioners want you to find the old closed appeals that perhaps the Form 9 was not properly logged. So how is VA already providing the relief?
So I want to make sure that we're distinguishing between providing the relief for the individual named petitioners here, which was reactivation of the appeals, and what I believe, Judge Meredith, you're asking is how VA is providing the relief as to the potential class. Is that correct?
Yes.
So here the secretary would ask the court find that VA's various procedures that exist now are sufficient for VA to identify VA Form 9s and to reactivate prematurely closed appeals. This is not a case in which VA has done nothing here. As noted and documented in our supplemental response, VA does have various levels of procedures, which is for the point of identifying these VA Form 9s and reactivating their appeals.
So let me ask you one more question on this topic. Has VA put out notice on its website or in newsletters and individual letters to claimants that appeals have been erroneously closed and they should contact VA if they have a concern that their appeal might be in that bunch?
No, Your Honor. As far as I know, that no such note has been provided. Turning to the commonality question, as Judge Meredith pointed out previously, that the petitioners have not presented any questions which would satisfy the commonality requirement here. Petitioners have presented 2 questions, the first of which is whether or not VA errs in closing and not reactivating appeals despite a timely filed VA Form 9. As Judge Meredith previously pointed out, this question does not drive at the error or the harm here, which is that the VA Form 9 is missed. The closing of an appeal is an administrative action that does not cause the harm, which is the missing of the VA Form 9. If VA were to not close its appeals in vehicles, this would still not resolve the error of the VA Form 9 being missed. Additionally, we would note that there are many potential reasons for why a VA Form 9 might be missed, to include delays in mail delivery, delays in mail processing, the veteran sending the VA Form 9 to the wrong office, or simply human error, as was the case for the named petitioners.
Mr. Yu, wouldn't this problem be solved in a lot of respects by, regardless of whether it's required? I'm not going to legal requirements. But if when vehicles, the automated function in vehicles determines on day 65 that there's no Form 9, an automatic letter is generated to the veteran that says, having failed to file a substantive appeal, your appeal has been deactivated. Nothing, let's just say that. Not even call a number, just that. Wouldn't that essentially solve this entire problem? Because somebody who then mailed in a Form 9 would pick up the phone and call and say, wait, I sent the form in, and then a human would go look, and you wouldn't have to look at everything. You'd only look at the places where they do that. And after all, when you actually make a quote decision, VA is required by Congress to actually notify a veteran. So you're in the business of notifying veterans of things. So the no notice point, whether we call it fair process, due process, or just common sense, it seems to me, I don't understand. That would be a simple way to fix this, wouldn't it?
To respond to Your Honor's question, I know you said that you wanted to exclude legal requirement, but my answer is fundamentally that VA is not required to provide notice when it closes an appeal in vehicles under the governing statutes and regulations.
I know, I'm just saying that you've talked about the burden of going back and looking at everything, and right, and maybe there are lots of reasons why this might happen, but the reality is that you close this, nobody knows that you've closed it unless they do something. And in this system, years can go by, right? Because it's a long system. But if on day 66, an automatic letter is spit out that just says your appeal has been closed, I'm not saying you're required to do that. I'm not taking any position on that. I'm saying that would fundamentally, essentially fix this problem, right?
We would still disagree with that characterization, Your Honor.
Well, let me ask you this, then I'll do it in little bits. And you've got extra time because when it expires, I'm going to have Dawn put 10 minutes on the clock. You would agree with me that if VA sent letters, like I'm saying, just the 1-sentence letter, your appeal has been closed, failing to file a timely notice of Form 9. You would agree with me that couldn't make this problem worse for veterans, right?
I will present to your, yes, we agree.
Oh, okay, I was going to say that one. I'd suggest you don't say yes, because then we're going down a whole other road. Okay, so then we're left with it's going to make it better, or it's not going to change anything at all. And I don't see how it could change nothing at all. Because I would think that if a veteran filed a Form 9 and then VA sends a letter that says your appeal is closed and we're going to do nothing because you didn't file a Form 9, at least a fair chunk of those people would then contact the agency. And you've already told me as soon as you know there's a Form 9 or that there's an issue, you're going to go look and reactivate the appeal.
Your Honor, I have 2 points I think are important to your hypothetical or the situation you're raising here. And the first is that in the SOC, claimants are notified that if VA does not receive a VA Form 9 within 60 days, their appeal will be closed. So they are provided with some notice that of potential closure in the future. The second point is that while I said that the notice would resolve the issues, I would like to clarify in this hypothetical, which I think can demonstrate that there is potential for confusion and potential detriment to claimants. And that is if a claimant were to file a VA Form 9 close to the expiration of the 60 days, it does take time for VA to process this VA Form 9. And during that time, before VA has processed that VA Form 9, it is possible that the petitioners or that the claimant's appeal will be automatically closed in vacals. And so where the potential confusion and detriment comes in is that on day 65, the vacals closes the appeal and the veteran receives a letter saying that their appeal is now closed because the VA Form 9 has not been received. And that's simply because the time processing needed to process that VA Form 9, which occurs, let's say, for example, a few days later. Now, a few days later, the claimant will now receive a second letter from VA saying that your appeal is actually open because the VA Form 9 has been received. And so it is potential confusion and detriment to the claimant because within a few days, they're receiving two contrary notices from VA regarding the status of their appeal. Now,
and so Mr. Yu, I'm going to let you go and you can spend time on this, but I get what you're saying, but it's difficult for me to believe that the secretary's position is that telling a veteran that their appeal has been closed would lead to confusion. Yes, in your hypothetical, it would, but of course, it is the secretary who set the date only 5 days after 60. But my point is, listen, at the end of the day, we may not be able to reach any of these issues. I think the point I'm trying to convey to the secretary and maybe some other people who might be listening is, there's a problem. You don't even know though the scope of the problem, and maybe there's something you can try to do to help these people who may be in this limbo, whether we can reach the question or not. And the secretary is certainly within his rights to simply say, nope, Congress didn't require it, we're not going to do it, and there we go, and that's fine. But it's just, you can tell, I think, by some of the questions that at least some of us are troubled by what's difficult to understand what's going on.
Yes, Your Honor, we will certainly take that under advisement. Not only should the court deny the RCA because the petitioners have not satisfied the requirements under Rule 23, because they have not satisfied numerosity and commonality, but additionally, petitioners have not demonstrated that a class action would be superior to a precedential decision as required under the court's holding in SCAR. So a precedential decision is superior to a class action because if the inherently transitory exception to mootness applies here, then there will never be a class. Once a prematurely closed appeal is identified, then VA's established policy is to reactivate that appeal. Then that claimant is immediately no longer part of the class. The only way to create the class and have class members is for the court to artificially create one by halting VA from following its established policy, by halting VA from reactivating these prematurely closed appeals to the detriment of veterans and other claimants. If VA follows its policies, then there were no members of the class. A precedential decision is superior because it is the only way for the court to address the merits arguments raised by petitioners, including those policies for reactivating prematurely closed appeals. Additionally, petitioners have not satisfied the superiority factors as established by this court in SCAR. Specifically, the second superiority factor, petitioners concede that there are no complex factual record development required in this case. Therefore, the presumption in favor of issuing a precedential decision should apply in this case. Regarding the fourth superiority factor, petitioners have not established that remedial enforcement is necessary in this case. This is not a situation in which VA is attempting to evade prior presidential decision. In fact, VA's policy is to reactivate these prematurely closed appeals whenever a timely filed VA Form 9 is identified. Here, the petitioner's appeals were closed due to human error. Petitioners have not demonstrated that class action is superior to a presidential decision in remedying human error. A presidential decision is at least as equally good at addressing the adequacy of VA's procedures as class action, and therefore the court should find that the presumption in favoring of issuing a presidential decision should apply in this case. If the court has no additional questions, and I will briefly conclude. But in conclusion, this court should dismiss the petition as moot. However, if the court finds that the exception to mootness applies, the court should issue a precedential decision denying the RCA and hold that first, the regulations permit VA to automatically close appeals in vehicles. Second, that notice is not required when VA closes an appeal in vehicles. And third, that VA's procedures and safeguards are adequate to ensure that prematurely closed appeals in vehicles are reactivated. Thank you, Your Honors.
Judge Meredith, do you have anything else?
I do not. Thank you.
Judge Laurer?
Thank you. One question. If the VA's process, as you stated, Mr. Yu, is to reactivate all erroneously closed appeals as soon as it learns that a timely Form 9 was filed, then no individual claimant could essentially possess a personal stake in the suit long enough for litigation to run its course. And it seems to me that that is the definition of inherently transitory.
Your Honor, in response to Your Honor, we would ask the court not apply the inherently transitory exception here because we would say that it's not certain that others who are similarly situated would suffer the same harm. Now, we acknowledge that VA's procedures are to reactivate a prematurely closed appeal, but given the declining number of legacy appeals since the full implementation of AMA in February 2019, and given VA's established policies to reactivate prematurely closed appeals, we would say that it's not certain that others who are similarly situated would suffer the same harm, such that the exception of mootness should apply here. We would also note that this is not a case in which the veterans' claims became moot due to their temporal nature. We would also note that the Secretary here has not mooted the individual claims in an attempt to evade judicial review, but because it is part of VA's established policy to reactivate these appeals.
Okay, and Mr. Yu, I'd also like to pose the same question that I posed to Mr. Niles, and that is, what should veterans do when they believe that their board appeal was improperly closed?
Counselor, the opposing counsel, I think, is right here that if the veteran were to feel that their appeal has been improperly handled, to include improperly closed, if they simply file request information or contact the RO and ask them to check the status of their appeal, that could itself be enough to trigger identification of that VA Form 9 and reactivation of their appeal.
Okay, but at the same time, you're acknowledging that there would be a group of veterans who would have no idea that they've submitted their Form 9 and they're used to the delays that have occurred, particularly in the legacy claims, and so therefore you're acknowledging there would be a group of veterans, perhaps some of whom most need the benefits, that would be totally unaware that their appeal has been automatically closed.
Yes, Your Honor, there are potentially this group of people. However, again, we would note that VA's various procedures, and we would say there are layers of procedures, which are designed to identify these VA Form 9s and to reactivate those prematurely closed appeals.
I have no further questions. Thank you.
Thank you. Thank you, Mr. Yu.
Thank you.
Mr. Niles, you've got we'll restore your rebuttal time.
Thank you, Your Honor. I have several points to try to go through them quickly. The first is during this court's discussion on commonality with my colleague, Mr. Yu, there was a question about what is the error driving the result here? And I think in the context of that question, I more fully understood the court's answer or the court's questions to myself. The error driving the result here is not that VA is misidentifying or going into any one particular soup of these potential types of human errors that then feed into vehicles erroneously closing the appeals. It is the erroneous closure and the subsequent withholding of all action on the appeals, which is unlawful, and petitioners address this further on page 14 of their request for class action. Judge Allen asked, with about 2 minutes and 10 seconds remaining before the time was extended, I believe, about, hey, once these appeals are closed, a letter, wouldn't that help? It would help somewhat, and I just want to clarify that would be on an ongoing basis. We are very concerned about these older appeals that have been erroneously closed and with all action withheld on them for so long, and so want to reiterate that as part of the remedy in this action, we would want those appeals addressed. So not just on a go-forward basis where there is a new erroneous closure, but also VA certainly can search and identify in vehicles all these erroneously closed appeals. And so we can identify that universe. We set up the class to work within those systems to be able to handle that. And so we have the universe there. A letter can go out to them, certainly. And I'll also note that if there is a concern raised about, well, VA having to go individually file by file to see which appeals were erroneously closed or timely or and not, if that's what it takes, that is what it takes. The Federal Circuit's been fairly clear about that, at least in the Lane decision fairly recently. And again, the petitioners have tried to limit this class to make it as narrow as possible to where we are getting the biggest bang for the buck here. We understand that VA has many, many commitments, but these are, they're legacy appellants who've been waiting years but some of them through no fault of their own, because VA has closed their appeals and not told them about it. As far as the single issue appellant as well, whose appeal was closed, I just wanted to highlight that another situation where something like that would occur is the case of a surviving spouse, where the appellant dies while the appeal is closed. There's no representation there, perhaps, and the surviving spouse is going to have a lot of trouble getting that message, particularly when VA is not sending any notice about the closure. I am going through my notes here because there's a lot of ground, and so adequate alternative. The court raised this question to me, and I heard it maybe come up just a little bit. Two responses here. Number one, this is not something that the secretary raised as a defense, other than just to cite that under the standard for issuing a writ of mandamus, adequate alternative is a requirement. But beyond that, not addressing it. And number two, I said that I had stated that there was no action that the petitioners had taken that would sort of be a demand essentially here. I did overlook that in August 31st, 2020, Ms. Freund did send a status inquiry letter to the Board of Veterans Appeals. And so I'd be happy to provide that afterward. I don't know whether a status inquiry to the board is going to be something that the court accepts as saying, hey, you can come here for adequate alternative, but if helpful to the court, we would be very happy to provide that. Those are, I believe that the briefing does address everything else that I heard, but of course, I'd be very happy to address any questions that the panel still has.
I just have one thing I just want to clarify. The petitioners are not asserting unreasonable delay such that it would trigger the obligation of the court to assess the track factors, right?
That is correct. This is an unlawful withholding case.
Thank you. That's actually very helpful. Judge Meredith, do you have anything else?
Do not, thank you.
Judge Laurer?
No, thank you.
Thank you, Mr. Niles. Thank you, Mr. Yu. We thank all the parties for the extensive briefing and the workout you've given our eyes in this case. And we will be back to you as soon as we can, and the matter is submitted.
And the court will be in recess.